You're standing on a dark stretch of road right now, staring at a crumpled bumper, and your heart is pounding right out of your chest because you just hit someone and you know your insurance lapsed last week. You're terrified that you're going to lose your house, your truck, and your paycheck over this one terrible mistake. But before you spiral into absolute panic, you need to understand exactly how the system works and what your actual options are. When you drive uninsured and hit someone, the legal system gives you two very distinct paths to walk down. Today, we're going to put those two paths head to head, compare them on the dimensions that actually matter, and figure out what happens next. This is education, not legal advice. I am an expert explaining the mechanics, but every state has different rules, and you must check your local laws. Let's look at the two paths. Option A is paying out of your own pocket, and option B is going bankrupt. First, we need to define a term you're going to hear constantly: personal liability. In everyday English, liability just means legal responsibility. When you cause a crash, you're legally responsible for the damage. You're responsible for fixing their car and paying their medical bills. That's your liability. If you had insurance, your insurance company would pay this liability for you. But since your insurance lapsed, that liability sits entirely on your shoulders. Let's look at option A first. Option A is the straight cash path. This is where you agree to pay for the damage yourself. You essentially act as your own insurance company. You take your savings, your tax refund, or your paycheck, and you hand it over to the other driver to cover their repairs and their doctor bills. On the dimension of simplicity, option A wins hands down. You just deal directly with the other person. But we need to define a critical legal document right now. A release of liability. A release of liability is a legally binding contract where the other driver agrees to take your money and promises to never sue you over this specific crash ever again. If you're going down option A, you absolutely must get a release of liability signed before you hand over a single dime. If you don't, you might pay them $5,000 today, and they can still turn around and sue you tomorrow. Now let's look at option B. Option B is the legal protection path, and it usually involves a heavy word: bankruptcy. Bankruptcy is a federal legal process that wipes out your debts when you absolutely can't pay them. When you hit someone without insurance, you suddenly owe them a massive debt. If you don't have the cash to cover it, option B is the emergency cord you pull. On the dimension of protecting your assets, option B is the ultimate shield. Let's define an asset right now. An asset is anything you own that has serious monetary value. Your house, your truck, your savings account, and your retirement fund are all assets. When you owe someone a massive amount of money from a crash, they can legally try to seize your assets to pay the debt. Option B stops that seizure dead in its tracks. Now, let's force option A and option B to battle it out. We'll compare them on the four dimensions that actually decide your fate when you're standing on the side of the road. Dimension 1 is total cost. Option A costs exactly what the damage is. If you rear-end the Honda and cause $3,000 in damage, option A costs you $3,000. But option B costs a different kind of money. When you declare bankruptcy to wipe out crash debt, you have to pay a lawyer to file the paperwork. As an example, a basic bankruptcy filing might cost you $1,500 just in legal fees. However, if you hit a brand new luxury car and the driver goes to the emergency room, the total bill might be $50,000. In that scenario, option A costs you $50,000, while option B costs you $1,500 and your credit score is bruised. The size of the damage decides which option is cheaper. Dimension 2 is who gets paid. This brings us to another legal term: garnishment. Option B is staring you right in the face. You've nothing for them to take, so you call a bankruptcy attorney and use the federal system to wipe the slate clean. But what if you're stuck in the middle? What if the damage is $20,000 and you only have $5,000 in the bank? This is where people make a fatal mistake. They try to do option A halfway. They offer the other driver their entire savings, but they forget to get the release of liability signed. Once the other driver takes your $5,000, their lawyer immediately sues you for the remaining $15,000. Then they get a judgment and they start garnishing your wages. If you're caught in the middle, you need to get a lawyer before you hand over a single penny. Let's define uninsured motorist coverage right now. This is critically important. Uninsured motorist coverage is a specific part of the other driver's insurance policy. It's designed to pay them when you don't have any insurance. When you hit them, their insurance company will open a claim under their uninsured motorist coverage. The insurance company pays to fix their car and pay their medical bills. It sounds great for them, but it doesn't let you off the hook. Once their insurance company pays them, something called subrogation begins. Subrogation is simply the legal right of an insurance company to step into the shoes of the person they just paid and sue you to get their money back. Their insurance company pays the other driver $20,000. Then, the insurance company's lawyers turn around and sue you for $20,000. The insurance company gets the judgment against you. They're ruthless about collecting it. They'll garnish your wages, freeze your bank account, and put a lien on your house. A lien is a legal claim against your property that forces you to pay the debt before you can ever sell that property. When the insurance company gets a lien on your house, you can't sell the house without handing all the profit directly to the insurance company. This is why driving uninsured is so incredibly dangerous. It isn't just the other driver you have to worry about. You're going up against a massive corporation with endless legal resources. This brings up one more term you must understand: comparative negligence. In some states, the blame for a crash isn't just black and white. Comparative negligence is a legal rule that splits the blame for an accident between the drivers involved. Let's say you hit someone while driving uninsured, but they slammed on their brakes for absolutely no reason. A jury might decide you're 80% responsible, but they're 20% responsible. If the total damage is $10,000, your legal liability drops to $8,000. This is a powerful tool, but proving comparative negligence requires a lawyer. You can't just tell the insurance company it was partially the other guy's fault and expect them to agree. When you're standing on the side of the road without an insurance card, you're completely exposed. You have two main paths. You can pay out of your own pocket, or you can rely on bankruptcy laws to wipe out the debt. The choice depends entirely on the size of the damage, the value of your assets, and whether the crash was a pure accident. If the damage is small, scrape the cash together and get a release of liability signed. If the damage is massive and threatens to destroy your financial future, you need to speak with a bankruptcy attorney to see if federal protection is right for your specific situation. And if the damage falls somewhere in the middle, or if you think the other driver shares some of the blame, you need a personal injury or civil defense attorney to fight for comparative negligence on your behalf. You can't navigate this alone, and you shouldn't try. The legal system will eat you alive if you just roll over and accept whatever the insurance company demands. Laws vary wildly by state, and the timelines to respond to a lawsuit are incredibly strict. Don't ignore the letters showing up in your mailbox. Don't pretend the problem will just vanish. If you were driving uninsured and caused a wreck, which path scares you more, emptying your savings to pay it off, or dealing with the legal system in bankruptcy? Let me know down in the comments. If this breakdown gave you the actual mechanics of how an uninsured crash gets handled behind the scenes, pass this video along to a coworker or a family member who might be stressing over a fender bender. Make sure you subscribe to Scribble Law so you always know the actual rules of the game before a massive corporation tries to use the legal system against your wallet.